Well, welcome to the fifth focus of our 2021 Mining Law Summit. Our topic, or this particular topic, is models for new legal structures, and in some respects, we're going back to a lot of the old legal structures. My guest today is Stan Dempsey, an old friend of mine, and we are both a longtime and probably founding members of the Society of Mining Law Antiquarians. We used to be young when we started the organization, but now we are antiquarians ourselves, or at least antiques. So welcome, Stan. Stan is a retired chairman of Royal Gold. And previous to that, he had a full career working both for Amex and for various law firms, and is a frequent contributor and commentator on mining law issues. So welcome, Stan, and I appreciate your taking your time to do this.
Glad to do it.
When Stan and I talked about how we wanted to do this, we decided that I would give sort of an introduction to some of the historical mining law issues or historic sources of information related to mining law, and the basic breakdown that we have is we started out with essentially regal control. In other words, it was controlled by the king or the prince or whoever was in charge. And the idea was to control both the minerals needed for warfare. And so that would include iron and copper for the making of bronze, for example, as well as gold and silver that was necessary for specie and running the finances of the empire. The other line that we have is what I refer to as tribal, because as Europe, particularly around the Balkans, emerged during the Dark Ages, and by Dark Ages we're going back to essentially the early days of the Roman Empire, and going on from there. There was a series of tribes, and the Greeks called them Scythians, and they called anyone that they didn't know about Scythians, but they had the expertise to conduct mining operations, and so they then became what was referred to as the free miners. And the distinction there is that whereas during this time most of the workers, the serfs, were tied to certain lands and to certain lords to conduct the farming. On the other hand, the miners, with that expertise that they had, were allowed to roam throughout Europe, and thus acquired the nomenclature of free miners. As things progressed, you came up with a hybrid model of what was going on, whereby the kings and bishops within the Carolingian Empire recognized this expertise and did what they could to induce or to entice these free miners into their areas where they had principally gold and silver deposits, to mine them to provide the metals required for coinage. And so what we find at this point was a series of treaties between the bishoprics of the Carolingian Empire or the Holy Roman Empire, depending on what you want to refer to it. And these were treaties, essentially our earliest codes, to induce the miners to come into the area. And you find within these treaties, and our best example is the Treaty of Trent in the 1100s, whereby you found that the miners were given certain rights to mine the deposit. And in essence, they had to sell all the production to the local mint, and then were paid from the results. I think that the best example that we have as we're going forward from this would be the Spanish territorial effort. And these were the codes that were developed for mining in the New World. It started out with in the 1550s with Viceroy Mendoza, who was the Viceroy of New Spain, and he promulgated a code that ironically turns out to include a great deal of the provisions of the 1872 mining law that we had in the United States, or in California and in Nevada. There were two codes that were developed, one in 1574 and another in 1783. The first one was in 1784, 1584, and then the second one in 1783. The 1783 code is the most comprehensive code, code, and I think that it's most significant to me in that it recognized both the granting of rights to the miners as well as having a significant environmental protection within that code, which was something very different than you found in most of the other codes or practices, simply because people were going into wilderness areas and they really weren't concerned about things like that. So I think that when you had the efforts in the New World, there was beginning to have a population of civilians in the area, and so there was considerable effort taken to provide protection for water and timber and various forms of pollution. So, and I think that in many respects, that code developed from the Spanish sources became the laws in throughout most of South America from there. With the discovery of gold in California, the miners that flocked to California excuse me, were essentially making up their own laws and adopted what the miners were doing in Mexico, and Chile, Peru, and to some extent the claim clubs from a lot of the settlers that were coming across the country. The claim clubs were simply a way of protecting rights to homesteads. But in essence, what they did was to define the size of claims, the fact that they protected the rights of people making, or the miners making a discovery, and also had in certain provisions as to what constituted abandonment of those properties. before someone else could essentially legally jump those claims. This is the law that eventually became the law in the United States through laws in 1866, 1870, and 1872. The real difference that you find in the United States mining laws is that the eventual rights that were granted included a right to acquire fee simple title, in other words, a full title to that land, where you had a discovery of minerals. And so I think that from this point, Stan, let's talk about some of the modern structures where we have both governmental agreements, whereby a mining company has made a deal with the government, and so under that context, we're looking at both constitutional and statutory provisions. So let's talk about what governments have in mind in terms of national motivation.
Give me a little more prompting. Maybe I ought to speak a little bit about a situation where a government actually passed a special act of parliament to include all of the rights in a situation. In Western Australia, when the major iron ore deposits were developed in the 1960s, it was obvious they were being developed in a very, you used the term wilderness. The Pilbara is north and west of Perth in Western Australia. And the iron ore deposits were enormous. And there was no infrastructure, no people, except indigenous people, the Aboriginal groups that were occupying that part of Western Australia. And when companies like Amex and BHP, Zinc Rio Tinto Australia got together, we put together joint ventures to build and operate those mines. But there was not a mining code that we had to work with. The way it was done was to set up a special act of the Parliament, which covered all of tenure issues, but also all of the infrastructure issues and everything down to the police force in our town that we completely built and owned and operated as a corporate body. So instead of being a municipal corporation under a general law, all of the activity of our town that we had to build, two of them actually, were done underneath a general act that covered everything. So considering that was before the age of environmental impact assessments and things like that, all of the negotiation between the companies and the government was done before the act was actually put together. It does provide a real security of tenure for the operators. It's an interesting example of how a state government, which had the states own the mineral rights, how they put that together.
So I think that's certainly what happens with the motivation after the identification of the mineral resources and obviously to develop wealth. We also have motivation here to develop skills of the population that particularly in an area like that in Western Australia, where I suppose that the only people that were living there would have been indigenous people that would be relied on to produce minerals.
There was a small Aboriginal component, and of course there were stockmen who did agriculture, mainly grazing of cattle. And so when we built a town of 3,000 people coming in from all parts of the world, expatriates and Western Australians, some of whom now fly in and fly out to it's 750 kilometers from Perth, the town of Newman. And so we really needed to train people too. The indigenous people were involved in some of the training, but people came from everywhere. So there were immigration issues, and all of that was comprehensively taken care of under the special act of the Parliament.
The some of the historic downsides that we have in looking at one of what we would consider undeveloped countries was that you wind up with a concentration of wealth and perhaps a lack of distribution of that wealth, and a lot of times the environmental damage that's caused by some of the some mining activities. And I think we've had some examples more recently of tailings dam failures. In terms of a mining law itself, let's why don't we look at what a mining code might require, and I think that the first one would certainly be a stable political environment. I suppose what you're looking in Australia, you've got a real stable government there. What's your observation in some of the other areas without a stable political environment?
Well, of course, probably the best example in the world of problems with stability would have to be the Bougainville situation that developed in the 1960s and 70s, where Consink Rio Tinto came into the island of Bougainville, which is just off the north side of Papua New Guinea, and found a major copper gold porphyry deposit and developed it without much attention to the conflict between being granted a mining license by the Australian Colonial Service, who had control of Bougainville, and the indigenous people themselves, who had their own customary land tenure arrangements. And unfortunately, that turned into quite a violent episode of civil war, and CRA built a major open pit copper gold mine with not too much attention to environmental practices, and ended up, even today, I think Rio Tinto is now still working with local people to try to sort that out. But it's one of the great stranded assets of the mining world, and it came about through that situation.
What would have been if you were in the position with being able to advise the company in situations like that? What do you think could have been done differently?
Well, actually, I was asked to consult with CRA at that time. I was with Amex and headed up their environmental department, environmental activities worldwide. And Amex had a very good reputation. CRA asked for help. They were having difficulty reading with the demands of the Papua New Guinea government, not the Bougainvillean government. They're separate issues. But I visited there in 1974. I believe it was 74. certainly in the mid 70s. And of course, had an interesting visit and examined everything in great detail. Some of our ideas at that time were to deal with the situation of the political issues involved with bringing in people from the highlands of New Guinea into as a workforce into Bougainville, where people are quite different in their cultural backgrounds. That was one of the things. And CRA was very good to work with. It's now part of Rio Tinto, but and good people trying to learn how to do this. But if I were advising today, I certainly think you would want to take into account the differences between the political situation in New Guinea, which is the west or the eastern side of the Papua New the entire New Guinea island. But it would take some work to figure out how to get that all done. Bougainville is seeking independence at this point, and I think their population voted something like 80 or 90% to do so. But Papua New Guinea itself, which is now independent, doesn't particularly want to give this territory up, and particularly the cash flow from a mine if it's restarted and rebuilt.
So it's really a matter of trying to, to look in the crystal ball as to the long-term political situation within the country, and trying to play the middle ground, if you will.
Right. It's easy to show the mistakes, and I'm sure that Rio Tinto would join me in saying that they recognize what was done wrong. In terms pragmatically, why did they get run out of there? But at this point, I think you need a completely new strategic environmental impact assessment to think through again every issue that would come up politically, technically, socially, the whole. It's one place in the world to do the whole job of analyzing this.
Yeah, well, and I think that it just shows the difficulty of coming up with a system where you have disparate ethnic groups that are contesting the ground. And I think we probably have any number of areas within the world to when that's been going on. So our first requirement here would be to have some sort of a suitable legislative and regulatory framework, and I suppose if the country is in flux, that is going to be a real problem for you.
Well, I think you have to recognize that something we're doing now that we didn't do in the 60s was recognize that each of the stakeholders has legitimate interests that they're advancing and want to preserve. And it's a lot of this is about attitude. And of course, I think the mining industry, the environmental community, NGOs, we're all struggling with how do we liberate the economic value of these enormous deposits like Bougainville, and yet save some of our cultural matters that are particularly important to the particular stakeholders. It's time to really listen to other people.
So you think that the end result is a matter of learning to listen to the disparate groups?
But I think listening would help the process of first deciding, is a mine appropriate here? Is there any reason why it should not be built? You take in the United States, of course, every place is special. Every place is now controversial. You go to a place like the UK and you find out that under their Town and Country Planning Act, they have mines in their national parks. They don't have a lot of minerals to waste. So
really, I think that brings us to environmental standards, and I think that your example in the United Kingdom is probably an excellent model for us to talk about. Why don't you give us an outline of the Town and Country Act?
the Town and Country Planning Act was set up, I think, in the late 50s, early 60s, 1960s. And it is set up so that the planning is comprehensive from a national point of view. The local councils do the first step in the Town and Country Planning Act, and they can approve a minor situation. If you want a new garden or a new garage on your house, you go to the local council and they work out the terms and conditions under which you may do that expansion of your property. If you're coming in with a nuclear plant or an offshore a port for offshore drilling, or you're putting in a major potash mine, and as they do in Yorkshire, then that gets called in on an exceptional basis to the national level, and then an impact statement is prepared. It's a very practical way of not trying to do an impact statement on every issue, every proposal that comes along. And your major issues that have been dealt with by the Town and Country Planning Act that have been, as I say, when the big nuclear plant that they put in, there was a controversy over mining copper in the Snowdonia National Park. There is mining going on in Devon and Cornwall International Park. The Lake District has a tungsten mine. Those have been called in, and more attention has been paid to them, but it doesn't waste resources on things that don't need to be studied.
I think that, we've talked about that before, and I think that the most significant element to me is the approval process under the act, that everything is pulled together with an overall evaluation, and then it's a single appeal if there is a dispute. Am I correct in my memory of that?
Yes, and it's something that's also going on all over the world except the United States, as far as I can see. There have been demands for reform and revision of our National Environmental Policy Act here in the United States, but most countries now have an EIS approach, but they're changing it into what's called a strategic environmental assessment, where they actually involve people earlier in the process, the public and all stakeholders. And the design of the project includes those impact hearing results and suggestions from the public. And very quickly, the decision is made whether we're going to try to build this thing and protect the environment, or we're not going to build it. We don't, I think in this country, it's 4.5 years on average to permit under NEPA a major mine, the type major copper mine, etc. It's most of the countries are doing it in 2 years now. They've had to accelerate because the uncertainty in the economic cycle is not in tune with the political cycle in most places. They're having this strategic assessment done on most of the wind power, particularly offshore wind power in Denmark, the UK, any number of countries. I think Ireland's got a similar situation.
Well, let's talk a little bit about what generally be referred to as the social contract. with mineral development and what mining companies are seeking to implement, or for that matter, that governments and NGOs are seeking to implement. Do you see any movement in that regard as to what we're facing in the future?
Well, of course, we're being pushed very fast by the investment community to do what's called ESG, environment, social, and governance, to get the act together, the mining industry as we go along, to seek community acceptance by organizing our approach to those three things: environment, social, and governance.
And do you think, are we talking mainly about appropriate consultation, or trying to identify the proper stakeholders for consultation?
Well, I think both. It's certainly clear to me now that community acceptance is accepted as a principle that we need to achieve. I'm trying to put that in different words, but
but I think that you're going to have certain areas that that just because of who is living there, that if you're talking about community acceptance, it tends to respond to the loudest voice.
well, certainly you have situations around the world where countries at the national level will seek royalties on mineral production, taxes, but they're not very generous with local governments, whether state level or local. And that's one of the issues that we all have to work on, because there are legitimate claims by local people that they're not getting enough of the pie. And of course, when it comes to the local communities providing labor, accepting some of the impact on their areas, they're contributing to infrastructure, they have to be compensated, and that has to be worked out. And
So you think in terms of what we should be looking at new mining acts would be more of a focus on returning revenue to the local community, as opposed to sending it back at the national level.
That's right. And certainly there have been some horrible examples in African countries that are fairly new in independence, where dictators have sent the largesse that we receive from the mine directly to Switzerland to buy a good gold watch. That's just not appropriate. And I think as the communications get better around the world, it's going to be less acceptable to local people.
Well, we've sort of touched on the financial obligations, and the fact that we need to ensure that the local governments are adequately recognized. We've talked about the fact that some sort of stable financial obligations are important. I know that, for example, in many countries, it's possible to negotiate a long-term royalty contract. What has been your experience in working with those provisions?
Well, of course, it's really a question of how much is the host country going to get out of this operation, and how much is the mining company. And of course, John, I've told you from time to time that I've had sort of a 50-50 approach in my mind. I think you may be able as a company to negotiate a better deal than that, but it may not turn out to be that good a deal over time. And I think the natural place that you end up, whether you want to or not, is going to be something close to half and half.
But I think that, whenever you have a 50-50 situation, the host government always want to have their 50% carried, and
First,
have a mining company responsible for all the expenses.
I think if we're all listening to each other in our negotiations, host countries will see it's to their advantage not to overburden take too much from the cow, I'm trying to say.
Well, hopefully that, and a lot of that comes with education. I suppose that when we look at developing countries, it's sometimes very, very difficult to find, the local engineers and politicians that truly appreciate the, the nature of burden that is imposed on a miner in an attempt to develop properties.
That's true. In certain situations where the company I was involved with dope mines in countries like Burkina Faso in West Africa, the local people didn't have the skills to build a mine of that sort. And it would surprise most people, I think, in the West to find out that most things like that are built by Chinese or Sri Lankan contractors that come in. And again, you have problems with the relations with local people. But I'm afraid that I have to say the U.S. people are not too, they need a lot of education about how things really work in the third world. I'm not saying it's bad that Chinese or the Sri Lankans are doing it. How else would you build a mine? You certainly can't do it with people who have no background at all, don't know how to run a screwdriver. And of course, in most situations, we're negotiating to and willingly wanting to use local people as much as possible, because that builds a more stable community for us in the mining industry. But you can't train them fast enough to bring in major equipment, and millwrights are not too frequently found in places like Burkina Faso.
So in your view, what do the Chinese know that we don't?
That's an interesting question. They are certainly investing all over the world, and they're also, with their Belt and Road Initiative, they're enjoying the benefit of getting the contracts to build the mines as well as invest in them. But I guess my point, John, would be that on many of these issues we're talking about, there are other countries in the world, Australia, Canada, the UK, France, who are all working in these areas, and they're coming up with different solutions to many of our issues, like environmental impact statements. Other people have good ideas that are not meant to lessen environmental controls necessarily, but how to make them more effective, both economically and in terms of having the law actually achieve what it's trying to do.
The next bullet point that I had on our outline was to talk about the need to have open export and import rules. I think that this seems to be one area that host countries tend to recognize.
Certainly in our situation in Burkina Faso, one of our issues was major equipment that was needed to build the mine or to install at the mine were all held up in South African ports. And we had the knowledge from our own background about using customs brokers to get that situation straightened out in South Africa. And of course, it was 1,000 kilometers or more to get the equipment into Burkina Faso. But Americans don't have much experience with how things really work, I'm afraid.
Well, let's talk about, looking at our models of some of the challenges that we have, and possibly it's a matter of accommodation of change. And we see it a lot in this country of the social acceptance of commodities. You see most press releases of mining companies when they're putting in a new mine will emphasize the fact that these minerals are needed for the new green economy, just because so much copper is going to be needed for wind generators, for solar panels and other things. And you wind up with a lot of changing technology, as well as changing environmental considerations. And this was something that intrigues me, is that at what point do you think that a host country might be able to require a mining company to change their mining techniques because of a change in technology? Or is that a legitimate concern?
Well, I guess I think in the situations where you're actually negotiating an investment agreement with the host country, things like that should be on the table. If we want to talk about doing autonomous mining underground or surface mining with driverless trucks, let's hear what the host country thinks they can do, and do they have the infrastructure that would actually support that? It may be a win-win for everybody. One thing I would like to say, John, on the legal side of it, I remember reading Dean Pound at the Harvard Law School years ago. But he was sort of a student of the mining district laws that preceded the 1872 mining law. And he pointed out that a mineral tenure law tends to be very conservative, and it isn't changed very much very often because of people's need for, they have big investments under the tenure laws, and they don't want to be they don't want the security of tenure problem to arise, and they need to be able to keep environmental laws. In his case, he was talking about zoning laws, but environmental laws need to be changed once in a while because we keep learning things. There's a lot of science involved in it. And if we fossilize our environmental laws by putting them directly into the mining codes, it's not in the best interest of the environment.
And I would think that it would be beneficial to be able to allow flexibility and perhaps some incentives to the miner to change mining techniques, for example, to conduct the operations in a less destructive manner. But the problem really amounts to the host country being able to provide some sort of financial incentives to do that, as opposed to financial disincentives.
It's interesting that a number of places around the world, indigenous people have actually started becoming part of the mining industry. Octedi in Papua New Guinea is now operated by a local concern. It's no longer a multinational company. The First Nation people in Canada, in a number of cases, are actually providing mining services to major mines that are being built on their lands. And that's all part of an agreement with the mining company. And I think as they come to be good operators, as I think they are at Octedi, I think we're going to see people working together to solve the problems. We want the benefit of the metals. In fact, we have to have the metals. If all the stranded assets, if all the mines that were controversially stopped right now in the US were given a permit tomorrow, it would still take 3 or 4 years for a Resolution Copper or a Twin Metals or any of these major copper mines to be built and operate. So if we're going to change the whole electric grid around the country and have all these electric cars by 2030, we need the metal now.
Yeah. Well, let's take a quick look at the last bullet point I have for our models. In essence, is whose responsibility is it for oversight and enforcement? We've looked at situations throughout the world where we've had special courts to address mining disputes. We've seen the Barmouth courts in England historically, and going back to even the Greek and Roman times, they had special courts or special considerations applied to mining disputes to make sure that the production did not get or did not slow. Do you think that we need some example or some continuation of those types of courts or dispute resolution issues?
Well, we certainly have some of that going on, because we're all over the world, we're adopting things like the cyanide code that was adopted about 10 or 15 years ago. And these are not instruments of government or creations of government. These are voluntary standard setting bodies. You have the ISO standards. And again, they're not regulations imposed by the government, but they are standards by which we can measure the performance of a mining company. I think that's going to be the trend. Our securities codes are not enforced by federal law. It's done internally in the bodies that create those codes. So I think we're going to see a lot of that.
Well, I think that sort of emphasizes the need for international arbitration of any of the disputes that come out of that. And I think that, which brings us really to the final concern here, is the confidence that you can have in the enforcement of any judgments, either of a local mining court or an arbitration. And we've seen some difficulties lately with judgments that are substantial judgments that are being opposed on an international level. Do you think that we need something that might be overseen by the United Nations to enforce major judgments?
Well, you certainly have that situation with the London judgment that came down on Rio Diki in Baluchistan, and that's controversial. I don't know what the facts are, but we're certainly going to have international bodies that have credibility. And for years, John, you and I both probably have sent people to London as a place that you have absolute certainty that they're going to be a fair place to be adjudicated. And whether that's still true anywhere in the world, who knows?
Yeah. Well, I think that to provide confidence of mineral development in some governments that might wind up to be unstable, you would need, it seems to me in the future, you're going to need some independent body where a claimant could go that would have some sort of enforcement authority to be able to secure or to enforce a judgment.
I certainly agree with you, John. Some of these mines that are being built today are $4 and $5 and $6 billion operations. Private capital is not going to be able to continue taking the risks they're taking. And of course, when you pay for insurance and pay for the overall cost of risk, the whole world is paying that cost. It gets passed on to the consumer at some point in time. So, I have some fear that private industry may not have a place in major mining in the future.
Well, that's an interesting thought for the future, Stan, and we can see whether or not the private capital has its place within the development of major mining operations, or whether or not we need to rely more and more on the backing of from governmental sources. And so I suppose that's the major thought for the future, for future consideration.
I meant to be provocative.
Good. Well, Stan, thank you very much for contributing your thoughts to this segment of our Mining Law Summit, and we'll continue to visit about these things, and hopefully the mining law antiquarians will have some thoughts to give to the future development based on what's happened in the past.
It's always a pleasure, John.
All right. Thanks a lot.